We have three wonderful speakers here. We'll be talking about legal and financial planning, preparing for the future. First speaker, well actually they're going to do it interactively, but we have Jill Wilson. She graduated from Berkeley School of Law in 1972 and spent the next 5 years working as a corporate lawyer for the Bank of America in San Francisco. During that time, when she was on maternity leave, she taught commercial law at KU Law School. Jill moved to Santa Cruz in 1979 when her husband accepted a job at the city of Santa Cruz. Having two small children, she worked for Ian McBeal, a local estate planning attorney, and 4 years later established her own legal practice handling wills, trusts, probate, trust administration, and Medi-Cal planning. Her community service has included serving as president of the Santa Cruz County Bar Association, serving on the boards of the Dominican Foundation, the Community Foundation, the Cabrillo College Foundation, Senior Legal Services, and the Alzheimer's Association. In 1995, she received the Rolling Hall Public Service Award by the Bar Association. In her spare time, Jill travels to Washington, D.C. with her husband to visit her son and daughter, who are also attorneys, and her two grandchildren. Our next speaker is Lucille Desjardins. She's been practicing private law locally here in Santa Cruz since 1993. She specializes in estate planning, wills, revocable trust, powers of attorney, advance directives, elder law, public benefits planning and special needs trust, conservatorships and guardianships, trust administration, and probate. Prior to that, she spent 10 years as a program director for the Advocacy Inc., the local ombudsman program, which provides support to elderly, frail, and memory-impaired older adults who are living in licensed care homes. Lucille has a strong appreciation of the roles and workings of family. In addition to her husband, 3 children, and 5 grandchildren, she is blessed to have close relationships with her 2 sisters, a brother, and numerous nieces and nephews. In her spare time, she enjoys running, bicycling, swimming, playing her clarinet, and listening to music. Lastly, our third speaker is Leticia Garcia. She's a social work supervisor for the Santa Cruz County In-Home Supportive Services, also known as IHSS. Leticia has worked for Santa Cruz County for 25 years, including the last 13 with IHSS. She also often does presentations for county staff about the IHSS program. In-Home Supportive Services pays for home care for low-income seniors and people with disabilities, helping them to remain in their homes as long as possible. IHSS is under the umbrella of the Adult and Long-Term Care Division of the Santa Cruz County Human Services Department. I forgot some housekeeping things that I was supposed to bring up. We will have a question. We've set aside time at the end for questions, so if you could hold your questions until the end. If everyone could make sure that their cell phones are off, and program evaluations will be handed out at the end, so if everyone can make sure that they complete one of those.
I want to tell you all that it's a pleasure to be here. Jill and I are going to sort of trade off on our presentation, and in the interest of time, we're limiting our presentation to long-term care issues, Medi-Cal in particular. If at the question and answer period you have questions about wills, trusts, or advanced planning, because that is important in Medi-Cal planning, hold those questions and we'll try to answer those. So what we're going to talk about is Medi-Cal as a payer for long-term care benefits. So, most of you may know that Medi-Cal is different than Medicare. Medicare is a program that we're entitled to under Social Security. Medi-Cal is a means-tested program. It's designed to provide services, medical services, including long-term nursing home care for people who are in need. And that means basically people who meet certain needs, benefits, standards. It's designed to help poor people. The program, unlike Medicare, is means tested. To be eligible for Medi-Cal, one needs to be at least 65 years of age, or blind, or disabled, and meet the asset requirements. The asset requirement, the means test is one needs to show that he or she has assets, countable assets of no more than $2,000. So that is daunting in itself. However, in order to qualify for Medi-Cal, there are many assets that are considered exempt assets, and they're not counted for Medi-Cal purposes. There's no income eligibility for Medi-Cal benefits, but if one who lives out in the community, a single person has income of more than $1,161 a month, that person, if he or she qualifies for Medi-Cal, will pay a share of cost. So if they have medical expenses, they qualify for Medi-Cal. They'll pay anything over that $1,161 as their share of cost before Medi-Cal picks up anything. If one's in a nursing home and receiving Medi-Cal, a single individual, that person will pay all of his or her income to the nursing home, except for $35 a month that they get to keep for their personal needs allowance. And then Medi-Cal picks up the rest. So let's talk about these exempt assets. We know that people can have no more than $2,000 in countable assets. So we need to know about the exempt assets to see if people will qualify. One of the biggest exempt assets is the personal residence. Currently, a person can own a residence of any value. That may change. We're going to talk about the rules for Medi-Cal as they're in existence today. They are expected to change perhaps as early as 2014, but we've been expecting that change for years and it just doesn't seem to come. The personal residence is exempt right now. Also, they don't count your household goods and your personal things, your heirloom jewelry, the things you have in your house aren't counted. One car is exempt. If you have an additional car, then you're going to have to determine the value of that car. If it's less than $2,000, that would reduce the $2,000 that you will have. You're entitled to term insurance of any value, but if you have whole life or insurance that you can cash in, that insurance is limited, the cash-in value is limited to $1,500. You can have a burial plot or plots, a prepaid irrevocable burial plan, or you can set aside up to $1,500 in a special account that you indicate is a plan for your burial account. It wouldn't be in your regular checking account. It would be a special account that's labeled for burial. You can have some annuities. And the annuity question gets a little complicated depending upon when you purchased the annuities. If they were purchased before August the 11th, 1993, you may be able to have annuities that are going to last beyond your lifetime. But if they're more recently purchased, your annuities have to be annuitized over your lifetime so that there won't be anything left when you die, so that you're going to receive regular payments of principal and income. And the idea is to prevent people from buying annuities to shield their assets and then dying and leaving this huge amount of money to their children or the beneficiaries that they've chosen. Other exempt property that's important is property that's used in a trade or business. So if you have a business, you may qualify for Medi-Cal, and you can exempt that business use property. Up to $6,000 in equity in other real property other than the residence, if the property is producing income at the rate of 6% of the market value of the property. And I don't see that used a lot. Another important exempt asset are IRAs. For someone who is at the age where you have to take distribution, if you are receiving minimum distribution or are required to receive the minimum distribution, then all of your IRAs are completely exempt. However, as you receive the distributions, those funds are income and they'll count as your share of costs. Other than exempt property, you can have some properties and still qualify for Medi-Cal if those properties are considered unavailable. For example, if you own a piece of property with other individuals and you're unable to sell it because the other people won't agree to sell it, then that property might be considered unavailable and it wouldn't be counted in that asset limitation of $2,000. So I think that's it for eligibility for a single person. And I'm going to pass the wand to Jill, and she can talk to you about married couples.
Oh, thank you for inviting me. Of all the areas of Medi-Cal, I think my preference is to help spouses when the other spouse is disabled and may need skilled nursing care, because I see a lot of couples where they've been married for years and years, and it's so tragic when one of them has cognitive problems or physical disabilities that will ultimately lead that person to need skilled nursing care. And coupled with the emotional trauma is obviously the financial concern about how that's going to be paid. So fortunately, we live in a state when they passed federal legislation, took the most generous course as it concerns the spouse at home. In Medi-Cal jargon, the person who's the able spouse who stays at home when the other spouse goes into a skilled nursing facility is called the community spouse. And then the other spouse is called the institutionalized spouse. So if I have Mr. and Mrs. Jones, who are my long-term clients, then what I hope I've done for them when they came in for their estate plan is to ask them how they feel about what would happen if one of them ever needed skilled nursing care. And hopefully they will give me a candid answer. Sometimes they'll say, well, we bought long-term care insurance, so we're not worried. Other times they'll say, if that happens to me, then I'm fine with you transferring my assets to my spouse because he or she has always been devoted to me, and that's the least that I can do. But oftentimes I have people come into my office when there hasn't been any planning, and we have to go over exactly what the criteria are for the spouse that's in the nursing home, the institutionalized spouse qualifying for Medi-Cal. And as I mentioned, California is more generous than a lot of states. Lucille went through the exempt assets. So what you do is you get a list of all the assets that the couple has, because all of the assets of either spouse, whether they're separate or community property assets, are countable. And a lot of people think that because it's maybe a second marriage and they brought in certain assets that are separate property, that those are going to be protected. Yes, they would be protected if the person got a divorce, but not in the Medi-Cal context, because Medi-Cal considers that community and separate property assets are all counted. And so, sort of piggybacking on what Lucille said, certain assets we're going to sort of put aside because they're not countable. And those assets are the family home of any value. They are, if the IRAs of the community spouse are not counted at all, the IRAs or retirement benefits of the institutionalized spouse are only counted as far as the income if the person is taking distributions. And then the spouse at home, in addition, gets to keep in 2013, and if you're following with our outline, it's on page 6, and that is $115,920. So the spouse at home, in addition to the residence, in addition to a car, burial plots, all the things that Lucille mentioned, can have $115,920. The spouse who's going to go into the nursing home, the institutionalized spouse, can keep $2,000, so the total is $117,920. And so some spouses have less than that amount in cash and stocks. Anything other than the exempt assets is considered countable. So some people fall neatly within that, and there's no problem, and so the only thing that they have to do, the community spouse, has to get the Medi-Cal application when the institutionalized spouse is actually institutionalized. A lot of people are under the misconception that you can plan ahead and you think that your spouse may need skilled nursing care, so you can get the Medi-Cal application, and then if they do, you're all set. But Medi-Cal won't accept an application unless somebody's actually institutionalized. For the obvious reason, they don't want to go through the process if the person is not actually in the facility at the time to make the application. Also, Medi-Cal is retroactive for 3 months, so if you want to make sure that your spouse is going to adjust to the facility, it might be wise to wait, at least a couple months to make sure it's a good adjustment before you actually go through the Medi-Cal process. It's not the worst thing in the world, but it is pretty time consuming and requires a lot of documentation. So what do we do if the couple has more than $117,000 in non-exempt assets? Well, we look at the asset they have and see whether we can sort of put them in different categories. For example, the obvious thing is if the couple has a residence, which is an exempt asset, but they have a mortgage, and maybe they have $300,000 instead of $117,000. If the mortgage is $300,000, then we just pay down the mortgage, and the mortgage is on an exempt asset, so we've reduced the countable assets to under the threshold. So again, we're home free. Also, some people wonder if a couple has real estate investments, how are those valued? They can either be valued at the appraised value or the assessed value. And I've had couples in my office where they might have had investment properties 30 years ago, something that might be worth $500,000 today, but has an assessed value because they bought it at $40,000. So that is an an acceptable value as far as Medi-Cal, the assessed value. So if someone has 2 rentals and they both have assessed values of $40,000 and $30,000, then they could fit within the community spouse resource allowance of $117,000. So there's quite a few options. And then there's also options of asking for an increase in the community spouse resource allowance through a court petition or a fair hearing. That gets a little bit more technical, but there are also options there so that if you consult with an attorney, then I'm sure that if the person is knowledgeable about Medi-Cal, they will explain those things. Now, sometimes people are sort of narrow-mindedly focused on qualifying for Medi-Cal. And one of the best things that I think I can offer is to ask them to look at the whole picture and not just get too narrowly focused on Medi-Cal. Because sometimes the transfer of assets or the qualification for Medi-Cal comes at a disadvantage for other aspects, particularly the IRS. For example, if a couple had a very expensive house and they've had it for a long time, it has a low-cost basis, maybe they paid $50,000 for it, and if one spouse died, the cost basis would step up to the market value of maybe $1 million. And if they qualify one spouse for Medi-Cal and they transfer the house away from that person, and that person dies first because they're the one that's disabled, the institutionalized spouse, they can lose the step up in basis. And so when you calculate the capital gains on $50,000 and a sale of $1 million, you end up with a lot larger number than most people would get the advantage of in terms of Medi-Cal if they were in a nursing home. They have to be there for like 20 years or something like that. So you need to look at all the different possibilities and make sure you're not getting carried away with Medi-Cal eligibility. And also you want to make sure that putting somebody in a skilled nursing facility, particularly if they have dementia, is a good idea. Sometimes it would be much better if the person could be in an assisted living facility where they have a dementia care unit and resources more attuned to somebody who has dementia. Particularly if the person wanders, it's often difficult to put them in a nursing home where they're with other people that are bedridden or so severely disabled that they can cause some sort of commotion in the facility. So I don't know if Lucille has anything to add.
I just wanted to make it clear that Medi-Cal pays only for skilled nursing care, it doesn't pay for assisted living, it doesn't pay for residential care. So if you're planning for Medi-Cal eligibility, you have to know that the goal is to place the person in a nursing home. I was going to speak a little bit about transfer of resources. That's one way of spending down to become qualified for Medi-Cal, and that's, I think that's an area where people have the most misinformation, and they tend to act precipitously and perhaps regret their actions. So I always encourage my clients to slow down and so that, as Jill explained before, we can look at the entire picture and maybe rearrange the assets, pay off the mortgage in order to spend down some of the countable assets rather than making gifts. But it is possible to transfer resources and still qualify for Medi-Cal. If you're receiving Medi-Cal simply for at-home care outside the nursing home, there's no penalty for a transfer of resources in California. So one could give away all the countable resources and qualify for home-based Medi-Cal. We don't recommend that generally, but that would be possible. However, in a situation where the person may need nursing home care, skilled nursing facility, paid for by Medi-Cal, there are transfer penalties. And if either the spouse or the applicant has transferred enough resources to pay for a month in a nursing home at the average private pay rate, and right now that's $7,549, that's the average cost of it in California of a month in nursing home care. Santa Cruz County, the average cost is higher, but we're looking at the statewide average. So if more than $75.49, and that amount goes up every year as the cost of nursing home care goes up. If more than that is transferred, within 30 months of the time of application for Medi-Cal, then there'll be a transfer penalty imposed, and the person will be denied benefits for 1 month for each $75.49 transfer. So if a certain sum has been transferred, what we do in order to calculate the penalty period is divide that sum by the average private pay rate, and then find out what the penalty period would be. And the applicant should not apply for benefits during that penalty period because they'll be denied and the penalty will be imposed. Those are for general transfers. Some transfers are exempt and they're not counted. You can transfer an unlimited amount of money for the benefit of the community spouse, but as Jill pointed out before, that may make you ineligible because you might have more than the community spouse resource allowance. You might have the over asset. You can also transfer an unlimited amount of funds to disabled or minor children without penalty. And another transfer. Well, we should. Yeah, those are the transfers that wouldn't be penalized. So when California adopts the new federal regulations that were enacted in 2000, went into effect at the federal level in 2006, the 2005 Deficit Reduction Act, we will the look-back period for transfers, instead of the 30-month look-back from the date of institutionalization. So when you go into the nursing home, Medi-Cal asks, when you apply for benefits, Medi-Cal wants to know if you've given away any assets within the last 30 months. And if you have, then the penalty period may apply. Under the new law that will be enacted maybe sometime in 2014, instead of a 30-month look-back, there'll be a 60-month or a 5-year look-back period. We are told that any transfers that are done before California adopts the final regulations to implement the Deficit Reduction Act, that those will be treated under the old rules. Do you have something to add, Jill?
I was just going to address the income, which I didn't address when I was talking about couples. And again, in acknowledgement of the fact that Lucille mentioned that if you're a single person and you're institutionalized, then the state of California, the Medi-Cal program, is going to require that your share of costs be all of the income that you receive less $35 a month for incidentals. But when one spouse of a couple is institutionalized, they're obviously the spouse that's the community spouse has to continue living in the home or wherever and has expenses of his or her own. So in that situation, the income is calculated differently. So on the top of page 7, I sort of outlined a hypothetical situation in which the husband received $3,000 in income and the wife, who had been a stay-at-home mom, had only received $500 a month. If the husband is institutionalized, then the wife will get to keep her own $500, plus she will be able to keep whatever of her husband's $3,000 income is necessary to bring her to another figure that changes every year. It's called the minimum monthly needs allowance, and that is $2,898. So she keeps her $500 plus whatever brings her up to that, and in this case it's $2,398. The flip side is if the wife is institutionalized, the husband gets $3,000, which is obviously over the minimum amount of $2,898, and so he can keep all of his income. So even if the husband got $10,000 in income, he could keep all of it when his wife was in the skilled facility. But if she was the spouse at home and her income was from sources that were payable to her, like her Social Security, was only $500, she can only take up to $2,898 of income, including what she got. The other thing we were going to address is estate claims. The trade-off when you qualify for Medi-Cal, whether as a single person or as one spouse and a couple, is that after the person dies, there's a potential payoff to the state of California. I guess all of us as citizens ought to be concerned that people who have resources that survive their death should possibly be used to pay back the state of California. If you're a single person, virtually the only asset you're going to have, because you can only have $2,000 in non-exempt assets, would be a home. So the state of California is supposed to be notified whenever a recipient of Medi-Cal dies so that they can institute a claim. And so if a single person has been on Medi-Cal and they die owning a home, then the home is subject to a claim unless the single person is survived by someone who is disabled, like a disabled child, in which case there is no claim. And the way the claim is calculated, remember we were talking about share of cost, that's the contribution of the institutionalized person to the state of California, after which Medi-Cal picks up the rest of the tab at the skilled nursing facility. So if the person's share of cost is $3,000 and the rate of pay reimbursement to the home is $8,000, then Medi-Cal is picking up $5,000. I think everyone sees that. So when the person dies, you multiply $5,000 times the number of months and you can get the claim amount. With a married person, if the person who's institutionalized dies first, there is no claim, although the state needs to be notified until the surviving spouse dies. When the surviving spouse dies, there's also a requirement that Medi-Cal be notified, and at that point, the state of California can assert a claim, again, unless there is a disabled child. There's a question in the back, but I think we've got to, we're going to wait, yeah, and then I think our time between Lucille and I is up, so I'm going to hand it over to Letitia.
Thank you. So after everyone sees the attorneys, then they are eligible for Medi-Cal, clients can get a benefit called in-home support services. That is a benefit that the County of Santa Cruz has, and it's throughout the state of California. And in Santa Cruz, we have 2 offices, one in Watsonville and one in Santa Cruz. And we have 2 supervisors, one in each office. We have 16 caring social workers. 14 are social workers and 2 are public health nurses. And we have 1 screener. Each worker carries about 170 cases. And at the end, you'll know why I mentioned that. In-home support services, like I said, it's a state-administered program that helps pay for assistance for a person to be able to stay at home instead of being in the hospital. It is cheaper to have someone at home than obviously in a nursing home because what we're going to pay a provider is way less than the state is going to have to pay when someone is in a nursing home. This program supports aged, blind, and disabled individuals. And I did have a PowerPoint, but I think you guys have copies of it, so I'll try to stay on course. The program offers services for domestic services, which means that someone can come into their home to clean their home, do their laundry, grocery shopping, pick up errands. It also authorizes services for personal care, helps them ambulate, helps them transfer, bathe, and also paramedical services if someone needs it. It can take them to the doctor. It also pays for services for protective supervision when someone has a cognitive impairment and they need 24-hour care. Again, like I said, that the people that are eligible for services must be 65 or older, blind or disabled. One of the requirements is that they cannot live safely at home without in-home support services. And they need to be financially unable to pay for services themselves, which means that they have to be on Medi-Cal, they have to be low income in order to receive the services. Some of the other eligibility factors is that they need to be U.S. citizens or qualified immigrants. They need to be California residents. They need to live in their own home, which means that if they are in a hospital or nursing home, that is not considered their own home. Assisted living is also not considered their own home. They need to be on Social Security or meet the eligibility for Social Security services. They need to be disabled and on Medi-Cal. And the reason why I say that is because there's many people on Medi-Cal, but they're not disabled. They are linked to the program because they may have minor children. So obviously those people may not be eligible for the program. If we do a visit and we find that they can remain at home with the services, then they are eligible. They need to have functional limitations that prevent them from caring for themselves. And they need to have a need that's going to last 12 months or longer. So if someone just needs services for 3 months, we may not authorize services for them. The application process, we actually have one person that takes all the applications that for the county. One of the things that happen is that we call her the screener. She confirms that someone is receiving medical services, and if someone is not receiving Medi-Cal, then she sends a referral to the Medi-Cal office. So if someone is not on Medi-Cal, one call is going to take care of both the IHSS and the Medi-Cal application. Recently, in last year, the state requires that every applicant for in-home support services has a health care certification completed by their licensed healthcare professional. So this form needs to be received before we can actually assign a case to a worker. So once the top 3 areas are completed, then the case goes to the supervisor, who then assigns it to a social worker or the nurse if we see that the need requires a nurse to do the visit instead of a social worker. The application process on page 9, then once the home visit is completed, then the worker needs to review all the information that they gather at the home visit, the form that the doctor completed, and any other workers from other agencies that may have information about why this applicant needs services. Then they decide whether this person qualifies for the service or not. If they are found eligible, the recipient will get a notice letting them know how many hours the program is going to pay for. If it was found that the person didn't need services, then they will get a denial notice, also letting them know why the service was denied. So then the next step after someone is approved is that they need to hire a provider. We call them in-home support services independent providers. The in-home support services recipient is considered the employer of any person that they hire to come and work for them. They are required they can hire anyone they want as long as the person meets the requirements. If they don't have someone that they know, and we have a list of providers through the public authority, that is one of the agencies under in-home support services, that has a list of providers that have completed the requirements, that they can send a list to the client so that they can interview someone from that list. Some of the requirements for the providers is that they need to have the legal right to work in the U.S. They need to have valid ID from the government. They must have a social security card. One of the new requirements is if someone has convictions, they cannot work for Medi-Cal, so they have to do a background check when they apply to be a provider. So the public authority actually gives them a live scan form where they have to get their fingerprints taken, and then when the results come back from the Department of Justice, if everything looks good, then they are qualified to be a provider for an in-home support services client. And then the next step is that how do providers get paid? Once all of the areas that I mentioned before get completed, then time cards get issued to the provider. The time cards actually go to the provider's address, not the recipient's. The provider needs to make sure that they fill out their time cards and put the hours that they worked. One of the things that I also, for providers, that I forgot to mention, is that they, besides doing their fingerprints and providing all the documents that they need to provide, they also need to complete an orientation. It's online, and they have to, when they call, they get a packet that mails to them, and if you guys have a copy of the packet, the website is on page 12, so you guys can refer to that. The recipient is actually also, when they hire the provider, they need to complete a form. And in that form, they give us the provider name, the address, birth date, when they started. And once all that is completed, then they get their time cards. Time cards get, there's 2 pay periods per month that they get. So it's the first time card is from the 1st to the 15th of the month, and then the next one is the 16th to the 31st. And time cards have to get signed by the provider and the recipient. And the pay for these providers is $11.50 an hour. And once they get completed, they need to be submitted to a time card processing center in Chico, California. If someone has a share of cost for Medi-Cal, they do pay the share of cost to the IHSS provider. So the way it works is that the IHSS provider sends their time card. Let's say they have $500 share of cost, and the IHSS hours amount to $1,000. The first $500 the recipient is going to pay. So what happens is that the state will send a letter to the recipient and the provider informing the recipient that they need to pay $500 to their provider, and to their provider letting them know that they need to collect $500 from the recipient. The provider will get a check stub, and the $500 are going to be deducted from their pay. And at the end of the year, they're going to get a W-2 And even though they didn't get the actual 500 from Medi-Cal, they got it from the client, they will be paying taxes on all that money that they earned for IHSS. For clients to avoid overpayments, they need to make sure that they let their in-home support services workers know anytime they are hospitalized or anytime there's changes, if they are out of their home for any reason, if somebody moves in or out of their home. Some of the statistics for IHSS in Santa Cruz County, we have about 2,300 clients. About 1,400 are SSI clients, meaning that they get their medical through Social Security, not the county. About 1,130 are over 65 years of age. 270 are, 1,130 are under, and 270 are over. Then around 870 are those are the Medi-Cal. So out of the 2,300, about 870 are receiving IHSS, and they have county Medi-Cal. Approximately about 580 of the 870 clients who are on Medi-Cal have a share of cost. And that's all I have. Then if you guys have questions on the last page, and I think if everyone got the copies, I did put the numbers of where to call for referrals. That's the first number on top, then Adult Protective Services and Veterans Office, and the Public Authority, that's the number for the providers. And then the Medical Benefits Call Center is also the number that I put there. So questions?
Check to see if it works.
Hello. For you?
It's working.
Okay. I have a question for the IHSS supervisor. Is the protective supervision for recipients with cognitive impairments, obviously the Alzheimer's and dementia, cognitive impairment, but is it only 24-hour care supervision, or is there, like my sister has 2 hours and 26 minutes a day, but it's a very long day when they leave at 11, 12 in the morning, and then she's alone for most of the day. Is there any way to have it not a 24-hour situation? Because obviously she has doctor's appointments and things that she has to go to that doesn't make sense to have somebody just sitting there babysitting.
Well, when we authorize protective supervision is when someone places themselves in danger. So if she wanders, you should call the social worker and talk to the social worker about the possibility of reassessing.
So does dementia, obviously is cognitive impairment, but is it only for 24-hour supervision? Because that's what I was told or understood, that you can't have, you can only have it if it's 24-hour necessary.
You have to be able to show us that you are going to provide 24-hour care, even though the program doesn't actually pay for 24 hours. The maximum that someone gets is $283, which is about 9 hours a day. But if we authorize the maximum because someone wanders, we have to have a plan in place that the family or anyone that's taking care of this person is going to watch them 24 hours.
The rest of the time?
The rest of the time, even though we don't pay for the full 24 hours.
And then the only other question is, when you have the time cards, it says the IHSS recipient, it's their responsibility to monitor the provider's time cards and must be signed and dated. But again, with cognitive impairment, my sister has no clue how much, the care providers come in and leave early or don't show up or whatever, and she just signs anything they put in front of her.
Yeah.
So I'm concerned that there's no oversight.
It's the recipient or their representative. So if there's someone in the family that's helping with her care or that is taking charge of her providers, then that person should complete an authorized form that we have, and then they can sign the time cards.
Except I'm 500 miles away, so I don't know from morning to morning when the caregiver comes or when they leave or how how much latitude they're taking. And I guess historically it's been very easy, of course, to rip off people with dementia. They take advantage.
The program has many limitations, and one of them is that the way it's set up, the recipient is considered the employer, and they are the ones that sign the time cards. When the workers are aware of things like that, they do flag the case and kind of keep an eye on things, but it's really difficult they each have about 170 cases, so they really can't keep track, but we do try.
Thank you.
Can family members be a provider?
Yes, they can, as long as they meet all the requirements.
And then, if they're a provider 24 hours a day, do they get paid for 24 hours a day?
No, they don't. The program is tax-based, so the state gives us a certain criteria of how much time it takes to do the laundry, for instance. The state has told us that to do laundry once a week is 1 hour.
But if there's a cognitive decline and they have to need 24-hour supervision, then
Then we may authorize protective supervision, but the maximum is 283 for
283,
someone
right,
Right.
a month,
a month.
right.
And when you divide that by 30, that's about 9 hours a day.
Right, so because when you say $11 and not, because my
11.
experience is they're not getting very much.
Correct.
All right, and then how does this work with veterans benefits? And if they get home health aid from the Veterans Services or something, can you authorize an additional provider? Does that work
As
out?
long as the provider that's working those hours doesn't do the same service that IHSS authorizes, it doesn't affect it. Obviously, if they're using the veteran service money to pay for someone to do the laundry, we are not going to authorize laundry because then it's being paid twice. So as long as the money is used for something different, it does not affect the IHSS.
Okay, and then if a patient has a cognitive disability and they're pretty functional, but they need their meds supervised. If they just had someone show up twice a day for meds, is that covered? Can
No.
you do that? Damn.
Well, we can authorize the time for meds twice a day, but again, if someone needs, it's not, and if you really think about it, how long does it really take to come and give someone their medication? 1-2 minutes, so
Yeah.
we may authorize 1-2 minutes twice a day for
Oh,
that.
so no one's
task.
gonna do that, really? Okay, because it's like, if you can keep someone in their home versus institutionalized, and all they would need is someone to give supervised meds, there doesn't seem to be anything for that, you know?
Well, not if someone is if you don't think that someone is safe.
Well, yeah, they think they're safe. Right.
Jill and Lucio, regarding Medi-Cal, when do those statistics and those criteria change, and who changes them and how often, like what year? Was that those figures you gave me?
Oh, with
The
Deficit Reduction Act, you mean when we're
Yeah.
gonna change the rules? We don't know, that's, I was alluding to the fact that we've all been waiting and thinking that next year they were going to implement the federal rules. The last that I've heard, and I think Jill will agree, that the projection was to 2014, but we've been told that before, so it's.
And the statistics you gave me here and the red requirements and all the figures, when were those initiated? What year?
Those were 1989, I believe, the medic.
They've been in place and they change their cost of living every
Right.
year.
Well, my mother died in 1977 and she tried to get Medi-Cal. And what happened is that there's 7 of us kids. We're all not living with her, and they called each one of us and asked us for money. Now, does Medi-Cal still do that?
No,
That was in 77, they did that.
things have changed.
That's what they did with my parents too.
Yeah, so they don't do that anymore. Okay. The other thing is, how is all this going to be affected by Obamacare?
We don't know. Do you have an idea?
Whatever
repeat the question each time?
How is this going to be affected by Obamacare?
ACA.
Well,
Lucille and I are primarily talking about, even though Medi-Cal is a healthcare provider, we're talking about the part of Medi-Cal that pays for the custodial care in an institution like a skilled nursing facility. So I don't personally think that Obamacare is going to have a lot of impact on the cost of skilled nursing
Oh,
facilities.
no, it won't affect.
For people in the community who get Medi-Cal, as their healthcare provider, it obviously there will be some impact on that, I think, but not the cost of skilled nursing facilities, which in this community runs about, between the low end, probably 7,500, the high end, 9,000, because it's very individual to the patient and how much, in the way of, diapers and pills and different things they have.
I have one more question. I'm sorry, I was full of questions. I know somebody that's on Medi-Cal, and she's been on Medi-Cal because she was disabled, and her mother died recently and left her with lots of annuities, 2 mobile homes and a house. And does somebody check up on these people and say, how are you doing this year, and has anything happened that changed things?
Each year, you have to, if you're a Medi-Cal recipient, you have to, there's the income allocation, which is reviewed each year. The resources typically are not reviewed that often. I mean, in terms of a couple, with a single person, I think they would review the resources.
It's a single
because
person,
she's probably over that, but it would come up in terms of tracking her income, because she'd suddenly be getting income from these resources that her mother gave her. So what somebody should have probably done with her mother is to say, your daughter's disabled, and however generous it is for you to leave her this money in your estate, it's going to put her off these benefits, which are probably pretty critical to her. So the appropriate thing would have been a special needs trust. And so
Well, I
sometimes,
don't think the state is doing a very good job, only because she's in a nursing home now, had a stroke, and she still has the 3 homes, and she still has the annuities. And I don't know, they're giving her $35 a day, like you said. The state takes all the money from her Medi-Cal, but she still has $35 a month. And I don't think they know about her 3 homes, and but anyway, I don't know, I just think there's some flaws there that are occurring. I don't know what they are, but it's kind of interesting, and I just wondered how you guys are finding those flaws. We're not. One who receives Medi-Cal is required by law to report any resources that they receive.
Well, now she's disabled and can't really.
Well, if she has a conservator, that person, if she doesn't, well, maybe there are some that fall between the cracks.
It's amazing, yeah. Thank you.
Thank you very much. I wanted to make a couple of comments and then to ask a question. First of all, just to say that there's lots of people who benefit from Medi-Cal and in-home support services, and it's great that we have it available to us. So, for people that don't own a home and don't have assets and things, and IHSS, all of these services are really wonderful for people that need them, and I've seen it be, both of those programs be very, very helpful. I wanted to just clarify that you don't need a lawyer to apply for Medi-Cal. Leticia had mentioned something about a lawyer, and while it's great to have a lawyer that can go through and look at the assets and figure out what you need to do with them, I wanted to ask about the share of cost, and if you could talk to us about if you do have a share of cost, what are appropriate ways of spending that down each month so that to meet that. So if you could speak to that. I understand caregiving is one of those ways of spending down that share of cost each month that then might qualify you to tap into in-home support services. So, and the last thing is that if I have my parent living with me, my widowed parent who doesn't have a home, who doesn't have more than $2,000 in the bank, or my sibling, my assets are not counted in terms of that person qualifying or not. So, you know, my mom who has Alzheimer's disease could live with me. I just wanted to, if you could address those things. Thank you.
Well, I think you mentioned about the share cost. And again, I don't work in Medi-Cal, so, but I do know that when someone has the share cost, they can buy like some kind of health insurance, dental insurance, something that's really inexpensive. And then they can ultimately qualify for a free Medi-Cal card. But again, we normally refer those people to HICAP,
Yeah.
which I think you guys have that. And your other question?
Just to clarify that my assets aren't counted if I'm caring for my mom. It's in my, that I'm caring for my mom.
Right, I mean,
For Medi-Cal.
as far as I know, they're not gonna count, only the person that's applying and their spouse's assets.
That's okay.
I just wanted to make a comment too, if I could, over here about HICAP, when we use acronyms, Leticia, I'm over here. But Health Insurance Counseling Advocacy Protection, or AIM Protection, ANPR, is available via consultation and appointments through Senior Network Services. So they can help you understand a broad scope of insurance, Medi-Cal, insurance, private insurance, and Medicare, Medi-Cal eligibilities.
I also have a share of cost question. Sorry. Sort of to piggyback, so a lot of family members are their loved ones in-home service provider, and sometimes they're living in the home. So when there is an excessive share of cost, excessive in the eyes of the family, I know it's not excessive in the eyes of the program eligibility, but let's say there's a high share of cost and the family feels like, well, if we pay the share of cost, we won't have money for the rent, we won't have money for food or other needed expenses. My understanding is the IHSS recipient doesn't actually have to show proof of any kind that they've actually paid the share of cost, and so even though the IHSS provider is getting that in their statement, my understanding is that when it's in the family, so to speak, so let's say the daughter, you know, is supposed to, the client's supposed to pay the daughter $700 share of cost, and the daughter says, well, we don't have to show any proof. The daughter's getting that $700 a month in her statement at the end of the year, but if she hasn't really collected it, is she just paying the taxes on that, which is probably cheaper than you know, actually showing that the client paid the share of cost?
Yeah,
Is that all legitimate? I mean, is that what they're doing?
we don't ask for proof that the share cost was paid.
Mm-hmm.
If the families decide to do it that way, I mean, we really can't enforce it.
Mm-hmm.
But the providers do need to know that they are going to pay taxes on this money.
Mm-hmm.
And it is like a job, so at the end of the year, they will get their W-2 and they have to pay taxes.
Okay, thank you. I always wondered about that. Thanks.
I wanted to know if you could speak on someone transferring from Santa Clara County to Santa Cruz County. My mom is on Medi-Cal. She gets IHSS. I'm her caregiver. If I decided to move back to Santa Cruz County and take her with me, is that a complicated process? Or is that kind of, do I have to reapply and all new?
Yeah. The first thing that you need to do, you need to decide obviously if you're going to move to Santa Cruz, and then you need to let your social worker in Santa Clara County know where you're moving to, and then the county sends an inter-county transfer to the new county where you're moving to, and they, the new county will need to do a reassessment visit so that there's no interruption in services.
Hello. Yeah, I'm sorry. I was wondering if it'd be okay to ask a question that wasn't related to Medi-Cal, with these people saying. So if someone with early onset has made their wishes known that they do not want to go to skilled nursing, they do not want to go into a nursing home, do I, as caregiver, have any legal options in terms of state of Oregon or some kind of option for assisted suicide? Sorry.
No, not in Santa Cruz, or not in California, no, it's just Oregon.
So it would have to be.
Yeah.
But
You have to live there for a while.
you can withhold all antibiotics, all treatments, all that stuff, so that, if you get a pneumonia, you're gonna die.
Well, again, I'll do what needs to be done. The issue is legal. Is there legal recourse? And the answer is no. Thank you.
Yeah, it's a little bit of cross conversation here. It's interesting though when you think about these are end of life issues and choices maybe via hospice that we might decide to not treat a urinary tract infection with an antibiotic. We treat the pain, but not the not the infection. Those are more kind of end of life kinds of decisions and issues. But it sounds like you're looking at the legality of choices and options for assisted suicide. No, but they're all good. They're all good questions. If that's what you need to know, they're all appropriate.
I work in home health, but I have a couple of curiosity questions while I have you. It makes my research easy. What's the tax base that provides the IHSS funding?
What?
What's the tax base that pays for IHSS? Property tax, income tax?
Well, the federal government pays a portion, the state pays a portion, and then the county has their own portion. So it's like 3 entities that it's paid for.
But you're not aware of which particular part of the tax?
No, I'm not.
Okay. And then because you're, I guess at least one of you in the introduction, maybe both of you are involved in Santa Cruz County government, Dominican Foundation, stuff like that. I've been curious since I moved up here about 4.5 years ago, why there's so few nursing homes. I work in home health and we're often finding Medi-Cal beds in Los Banos. So what is it about this county and community that's either blocking or not amenable, or what's going on right there?
Well, I think that several of the nursing homes that were in existence when I started Medi-Cal planning have gone out of business. One is Batterson's, and then I think there have been a couple other. I think that there's a high cost of living in Santa Cruz, so it's probably harder for them to get workers, at low wages. I think there are a number of factors, but you're probably right. And with an aging population, we're probably all going to be in really bad trouble when our need comes up. But
Especially for dementia, because nursing homes don't want to.
Yeah. And I've always thought it was the high cost of buying property and developing a nursing home. It's just not cost effective.
I would say that maybe with a lot of the legal requirements and things that are involved, and perhaps the high rate of property and things like that too. I'm going to come back out to you guys too. I'll walk around so keep your hands up so we can continue to address questions. But this one was written on a card, so I'll just address this one to you guys first. If a person can pay, has the capacity, has more to do with tax deductions and what's appropriate to deduct as far as medical expenses on your taxes. So if a person can afford to pay for in-home care, you've hired a private person to pay for it, the question is that this is not an appropriate deduction. Now, I always thought that it was, but I'll let you guys respond to this. It appears that only nursing home care and medical care is tax deductible. Why is all of this care and the expenses paid out? Why are they not tax deductible? Can you all speak to that, Lucille or Jill? What do you think?
Like home health care?
Yeah, being able to just deduct things like adult day programs and home care and those types of things, which my understanding was you could, but I know you aren't accountants, but it's more an accountant.
I'm not an income income tax expert, so I guess I take a cop out and I refer people back to their CPAs, since the CPAs are actually, completing their returns, or if a person does their own taxes, then I try to refer them to some other resources. But it's my understanding that not all care that people receive at home is deductible, but to the extent it's sort of quasi-medical, or that if they didn't get it at home, they would have to get it in an institution. So for that reason, I think a lot of people who are in assisted living deduct a portion, perhaps not all of the cost of the assisted living, whereas I believe that the entire cost of skilled nursing care is deductible. So but maybe Lucille has something to add.
That's my understanding as well.
I was just going to add one thing to that, and that is that there is a federal tax deduction for caregivers that you can do on your federal income tax. However, you have to be able to deduct. You have to have receipts and be able to deduct those expenses, but you can do that. There's nothing in the state income tax that allows for that. Just to come back to the gentleman's question about the lack of skilled nursing facilities as well, I'll just say that that is a trend right now. The movement is away from skilled nursing care and into less restrictive care, and a lot of the skilled nursing facilities have started to close around the state and around the country as well. There's just fewer of them, and it's harder and harder for people to meet the criteria for that kind of care.
Kelly, where are you? Oh, there we go. You've got that microphone. If you'll handle that side, I'll get this one. There we go.
I'm just wondering if someone could speak to the long-term care insurance. I see it's on this outline, but we didn't really talk about it. And who it's, I mean, when should people start thinking about it, and should everyone be thinking about it?
Well, I think a lot more people are thinking about long-term care insurance, and if the pros are the sooner you do it, the lower your premium might be. The downside is that if you purchase long-term care insurance and then can't continue to pay the premium because you're impoverished and elderly, and then the policy lapses because of non-payment when just at the time you need it, that might be a problem. But I'm seeing more people with long-term care insurance than ever before, because we're all seeing that we're going to need care. I think we're all aware of the aging population, and we're watching our parents and what's happening with them.
My experience is that a lot of people have the money to pay for in-home care if they chose to do so, but I think what happens to a lot of my clients, particularly as they round 80 or even older, they become very frugal, because today's cost of getting an in-home caregiver, which may range from $15 to $25, is exorbitant to them, and they all have a concept that they're going to have a retired nurse come and stay on their sofa bed and take care of them for $3 an hour or some absurd thing like that. And so the reason I think a lot of people benefit from long-term care insurance is that it gives them permission to get the kind of care that they actually need, so that they don't end up in an institution. So for that reason, I encourage people to get long-term care insurance, particularly if it'll pay for in-home care or a lesser level like assisted living or something like that.
But to be sure to read the policy, because some of those policies will pay like $25 a day for in-home care, which is equivalent to maybe an hour. So you have to read the policy.
Yeah. Or if you just were realistic, I think a lot of elders talk with their children and said, well, I'd like to leave you an inheritance. On the other hand, I don't want to go into a nursing home, and so if I need in-home care and I'm resisting it, please urge me to get it, because so many times people end up in a nursing home because they fell and broke their hip, because they're on a ladder or some other absurd thing that they should never be doing in the first place. And if they just got people in to help them clean their homes or whatever, it would make it a lot simpler. But
And I think also, it's like with any insurance plan, they're complicated. There are a lot of, the beast is in the details. And it's certainly, if you obtain your insurance earlier on, you're going to have lower premiums, right? Because you're paying into it for a longer period of time. And there are other conversations about being able to pay just sort of into a private insurance plan. And then I'm going to look at Ruth here, our public policy director, Ruth Gay, because she's in the room with us too and shared something earlier for her knowledge. But I believe there used to be, at least several years ago, under the state of California, there were sort of a couple plans, long-term care insurance plans that were adopted, and there was also some guidance and advice that you could seek around accessing, what would be the best plan for you. Is that still correct, Ruth?
California has adopted some plans for the state people who live in the state. CalPERS has plans.
That's gone.
But
To say that there's ones that they endorse or support in any specific way, I would say I'm not aware of that.
And CalPERS is closed at this time for long-term care.
Okay, thank you. That's probably maybe who was governing it before CalPERS, and I was a little removed from that resource for a bit, so, okay, thank you.
It's taken about 6 months for my patients to collect on theirs, 6 months or more.
Okay, to collect on a plan that they do have in place and they've been paying their premiums on, and then they need some consultation on that. And I would assume that when families run into trouble like that, senior legal aid advices can help them with some consult on that. Is what the idea I would throw out there as a local resource.
And for the lawyers, regarding the spend down, is it still allowable, even though it might be considered an illegal transfer, for Medi-Cal and in long-term care, for writing out checks in less than that $7,000 amounts, where the medical worker is looking at it, it's like, oh, you wrote 3 checks here for $6,000. That's probably an illegal transfer, but we can't penalize you for that. Is that still true?
I mean, basically, it's still allowable. I don't think it's going to be allowable under the new federal legislation. But what she's referring to is there's this average rate of pay, which is now $75.49, so $7,549 a month. So every time you transfer an amount over that, you are ineligible for 1 month for every approximately $7,500 you transfer. So the way people skirt underneath the wire, so to speak, is that they make transfers of amounts less than that. For example, if I had $75,000 and I transferred it in one fell swoop, the state of California would say, well, you're ineligible for approximately, it would be 9 months, because you could have, Jill, you could have used your $7,500 a month to pay for long-term care, and that's what we think you should have done. But if instead I make 9 transfers of $7,450 a month, I mean, at one time, or right under the threshold, then I can do that, and I can make the transfers as often as 1 a day to 1 person. So if I had 9 children, I could do that in a day. So it is kind of an unusual situation that people can do that, but right now it's permissible. But the other thing that comes up is that if individuals are competent, they can do this, but most competent people are not transferring that much money to their children or to other people, because you can't even pry out of them $15 an hour. So they're not going to be transferring $7,500. But so that the issue becomes, well, if these people are incompetent and their relatives want them to have the money transferred so that they can preserve an estate or whatever, then do they have documents in place that would allow that kind of transfer? Because normally, if you sign a power of attorney, you're not enabling your attorney, in fact, to summarily just transfer all your assets away. But in some cases, particularly if people want that done, Lucille and I put a caveat in the power of attorney that in the event that the person needs skilled nursing care or long-term care, it could be permissible to transfer the assets even to the person who is the attorney in fact, which is normally a breach of fiduciary duty.
Okay, then one final question. If a person is on Medi-Cal, let's say 2 years, but is taken out of long-term care, let's say in February, dies in March, no longer on Medi-Cal, there is no lien put on the home because they did not die while on Medi-Cal, even though they might have been on Medi-Cal for the last, 3 years. Would that be correct?
When someone dies, I believe the Medi-Cal claim is, if they're a single person and they don't have a disabled child, it includes anything that they've received from Medi-Cal after age 55.
That's right.
Could you say that a little more loudly, Jill, if you don't mind? I'm not sure everybody can hear you in the back.
Trouble with my voice.
Or Lucille.
Doesn't work.
When someone dies, there's a requirement of whoever's handling their estate to notify the Department of Health Services that a Medi-Cal recipient died. Then the state of California can put in a claim for any Medi-Cal benefits that that person received, whether in the community or in a skilled nursing facility that they received after age 55.
That's right, and generally people think that it's some kind of a lien. It's not a lien. When, after the person dies, the Department of Health Services has to receive notice, and they'll send it, after that time, they send an itemized bill for their estate claim.
Even though they don't die on Medi-Cal?
Yes, even though, if you've ever received Medi-Cal, or if your husband, maybe I never received Medi-Cal at all, but my husband received Medi-Cal, then after I die, whoever handles my estate has to notify Department of Health Services, and they're going to claim against my husband's use.
Can they put it on your estate, like in jewelry, your clothes, your furniture, or not?
Well, I've seen them claim against automobiles, but I think that's fairly unusual. They just look at the value of your estate, and whoever's responsible for the estate is required to use the extent of the estate to pay off the claim. It's just like any creditor's claim.
It's always important to protect your home, but I guess equally as important to be able to, pay for the care that you're receiving as well. It's always a huge balance in those details, I know. So it is about 12:29 now, and we would end at 12:30. Is there anyone, I see one hand up front, anyone else who had a question that they really needed to have addressed that we didn't do yet? So one in the back. So let me do that really quickly in the back, and then if you wouldn't mind, we can have the panel. Could you all stay for a little bit extra? Okay, for a few minutes afterwards, and then you can come on up and approach the panel. I'd like to remind everybody to please complete the evaluation form based on, our speakers and the content that you were expecting today, and whether or not we addressed that well for you. There are a lot of details in these kind of questions, but we hope you gave you a good beginning and support on that. So Kelly's making her way back there. If it's addressed quickly, we could do the other one. And lunch will begin at 12:30, but you're always welcome to go in there. It's a buffet style, so you'll have plenty of time. But don't leave yet. Please hang on just a sec for that. Kelly, are you ready with that question? Okay.
Yes, she wrote it down. My grandma lives in San Francisco, and her only asset is her Social Security and life insurance. Does she qualify for IHSS? Her 24-hour service. Her age is 100 years old, and she lives in her own apartment.
She should be eligible because she's on Social Security. So you should call that county office, in-home support services office, and apply.
Okay, that was a good question. One more quick one.
However, in order to qualify for in-home support services, she needs to qualify for Medi-Cal. So if the value of her life insurance, if it's a whole life policy, and if it exceeds, if it causes for assets to exceed $2,000, then she would not qualify for Medi-Cal.
What does that mean? When it pays
The cash-in value, that's what they look at.
That's sort of the bottom line, and when you go, you exceed that, then you're ineligible, correct?
Yeah, that's right.
Okay. One last question?
I'm looking at the Alzheimer's Association brochure on legal plans to assist a person with dementia. And on page 6, it says that the power of attorney does not give the appointed person, the agent, the authority to override any decision-making of the person with dementia, and that the person with dementia maintains the right to make his or her own decisions even if they're not good decisions. So my question for you is, the next sentence says, once a person with dementia is no longer able to make decisions. So my question is, who decides that? What does it take to have somebody with dementia who decides, you know, I don't want to wear that dress, or I don't want to go to the doctor, or I don't want to take my pills, you know you can't feed me that, whatever. When does the person with cognitive impairment become unable to work, you know, speak for themselves?
Well, we're all presumed to have capacity, unless there's been a determination, a court determination of incapacity. So
you
with
have to
the
go to
absent
court.
conservatorship, theoretically, the person should be able to decide. However, as a practical matter, once you have a certain amount of dementia, your ability
Right.
to advocate for yourself is...
So a diagnosis of dementia is not adequate to make the decision?
No.
Okay. I was told that it takes at least $10,000 to have somebody conserved. Is that true?
That's pretty close as for an average
Wow.
conservatorship. Maybe more, it depends.
And-
It depends.
And where do you get that money from? I mean, who, you know, if
You
somebody's a
get it
Medi-Cal, Medicare recipient and they're on IHSS and they have multiple diagnoses of dementia, all of a sudden you're supposed to come up with 10 grand to say they're not
There are
working?
some self-help programs for conservatorships now through the court system.
And you just call the court or senior legal or somebody and
Yes.
say, help?
Right.
Okay, and it says it takes quite a long time to do that. How long is it says it takes quite a long time. Is that like 6 months or a year or what?
Well, one must fill out all the paperwork and file it with the court, and then after it's filed with the court, presuming the paperwork is correct, you have to wait at least 6 weeks before you get a court date, unless there's an emergency, and an emergency usually deals with a financial emergency that would jeopardize the person's estate.
Can't you say they're unsafe in their own home?
Well, you could, yes, for a conservatorship of the person if they're unsafe.
Yeah, and if someone is unsafe in their home, you'd want to contact Adult Protective Services through the County of Santa Cruz, and they'd be able to come out and appoint a social worker that could come out and explore the situation and help correct things and hopefully enable the family member to live in their home too, so not necessarily have to move. So I recognize that we're